Okay, everyone. Today's presentation is going to be a lot of history facts. And so I apologize for all the information. I'm going to try and not give too much detail, but I want to try and show how the government of the United States began and how the Constitution gives us the three branches of our government. So I'd like to start with a quotation from George Washington. The power under the Constitution will always be in the people. It is entrusted for certain defined purposes and for a certain limited time to representatives of their own choosing, and whenever it is executed contrary to their interest or not agreeable to their wishes, their servants can and undoubtedly be recalled, which is he's describing the elections. And then this one, next quote is from John Adams. It is by balancing each of these powers against the other that the efforts in human nature toward tyranny can alone be checked and restrained, and any degree of freedom preserved in the Constitution. So the framers of the U.S. Constitution saw that the checks and balances are essential for the security of liberty under the Constitution. So we have the separation of powers. Some say it's shared powers that were devised by the framers of the Constitution, and it was designed to do one primary thing: to prevent the majority from ruling with an iron fist. Based on their experience, the framers shied away from giving any branch of the new government too much power. So this separation of powers is known as checks and balances. So we have from the Constitution, Article 1 is the legislative branch, and it makes the laws. And that one branch, excuse me, is divided into two branches, which is the House and the Senate. Article 2 of the Constitution gives us the executive branch, and it executes the laws. And it includes the president, the vice president, the cabinet, and other agencies. Article 3 is the judicial branch. They explain or interpret the laws. That includes the Supreme Court and the district courts underneath, and then other federal courts under them. So what I'd like to do is go through and show you that how they are connected to each other, and that they give a check to each other. They all have power to do duties for the people, but they have powers to check each other. And so I'd like to go through this for us today. So we'll begin with the executive branch being checked by the Congress. When I say Congress, that means House and Senate. So as we witnessed last year, we saw that the House of Representatives has impeachment power, which is a check on the president should he violate things within the Constitution and against Congress and against the people. But the trial of the impeachment is done by the Senate. So you see where the two houses each have separate things, separate responsibilities and powers to check the executive, but it takes both of them to actually remove the president. They can override a presidential veto if the president decides he doesn't like a bill that comes from the legislative branch. The president can veto it, but the House can also override his veto with 2/3 of a vote from both houses. The Senate approves or rejects departmental appointments, such as the Department of Defense head, the Attorney General, whoever heads a major department in the cabinet. The Senate also approves, rejects treaties and ambassadors. They have the power to declare war. This is a really important power keep this in your mind, that they alone, the Congress, is to declare war, not the president. And in tomorrow's, later, the second presentation, I'll show how important this power is. The legislative branch also has the power to tax and allocate funds. And a lot of times the presidents, they can control something that they believe is not constitutional by withholding the funds from the president. And then the president must from time to time deliver a State of the Union address. Now, Congress has a check also on the judiciary branch. So the Senate approves federal judges and justices. They can also impeach, the House can also impeach a judge if he does something that's in violation of the Constitution or within his power. They, the Senate is also the one that will hold the trial for the impeachment. And if there's a decision that the Congress does not agree with, they can actually initiate a constitutional amendment to override the Supreme Court decision. The legislature also has the power to set up additional courts that are under the Supreme Court, and they can set the jurisdiction. They can decide what cases the courts can settle on. Within the legislative branch, they also have self-check in that both the bills must be passed by both houses. So this, when a bill is written up, the Senate and the House must agree on the bill in its original form once they come to an agreement. The House of Representatives can only originate the revenue bills in order to bring income revenue into the government's bank accounts. And then all journals are to be published so that the public can know exactly what the proceedings are at the close of each session of Congress.
Can you repeat that portion? She switches over the video, a little bit blurry.
Okay. There is self-check in the legislative branch.
Can I switch over to this one? Are you over to this camera? Sorry about this.
Okay. Okay, so the bills must be passed by both houses. Revenue bills must originate in the House. There can be no adjournment over 3 days without consent of the other house. And then all journals are to be published publicly for the people to be able to know what was going on in that session of Congress. And I would like to say that all of these things, and I didn't list all of them, but the ones I'm bringing up all come from the Constitution, from these articles, to show that the government indeed was written up and given a guideline on how it is to operate. So the executive branch, which is the president is the head of the executive branch, he has the power to veto any bill that is sent from Congress. The vice president serves as the head of the Senate, as the president of the Senate. It's usually purely ceremonial, but he also is the one that casts the tie-breaking vote. In fact, the first time a tie-breaking vote was cast was in July 18th, 1789, and they voted to protect the president's sole authority over the removal of appointees. Keep that in mind and I'll bring that up tomorrow also. The president is also the commander-in-chief of the military, which is making a civilian of the nation actually the supreme military leader with all privileges. When the when the Congress goes into recess and the president wants to fill vacancies, he can actually make an appointment during that recess. He can call an emergency session of one or both houses, should there be a war or emergency, or for them to consider nominations that he would like to have in his cabinet. And he can also force an adjournment when both houses cannot agree on an adjournment, and that has never been done before. And here's an interesting one, that the compensation, his compensation cannot be diminished. And I looked that up to find out what exactly does that mean. And it actually comes from a history in the colonies when the king, he appointed the governors of the colonies that were still under Britain, but the colonies provided the salary of that governor. And if he did things they didn't like, they would actually cut his pay. And so I was thinking of the framers, and they knew this history. They had a broad history, and they had read the philosophers, and they saw governments that had various forms, and they picked out the best, and they took things and then tweaked it. And so they had that history of seeing someone's compensation being, actually they were being retaliated. So they put that in the Constitution so that the president could not be retaliated against by reducing his salary from the Congress. And then he has executive privilege, which we will hear a lot of in the next presentation. And he can have that, state that, but then he must, Congress then has to prove that the material he is claiming to be executive privilege is relevant to the case. And then the checks on the judiciary that the president has is that he appoints the judges, which is an influence in the direction of the court. And he also can give pardons, which is taking someone who has been convicted of a crime and completely pardoning them. And the conviction is totally taken away as if it never happened. And he can also reduce the severity of a punishment, which is called a reprieve. And then the other check on the president is that the vice president and the cabinet can vote that the president is unable to do his job. I don't know that I've ever seen anything in history on that one ever happening. Okay, so the judicial branch is the Supreme Court and the district courts. And the checks that they have on the legislative branch is that they do a judicial review, which means when Congress passes a bill, the Supreme Court has the authority to review that bill to make sure it's constitutional. And if it is not, it will be stated to be unconstitutional, and they'll have to rewrite the law. The other check on the Congress is that the Supreme Court and the district court judges have a lifetime appointment. So they are neutral. They are to be neutral. And as long as they are in, quote, good behavior, they cannot be removed unless they've done something that requires an impeachment of a crime. And also their compensation cannot be reduced either. And then the checks on the executive branch is a judicial review to make sure that the actions of the president are not unconstitutional. So we have a lot of history to look at in the next presentation that shows various events that have happened that will be challenging these three branches of government. So what I'd like to spend a little more time on, particularly beyond the three branches, is within that executive branch, there is something called the unitary executive power. And basically, it's a pyramid of hierarchy showing the president is number one, and under him is the vice president. And then he has his cabinet, and right now we have 15 departments. And then under the cabinet are hundreds of agencies, maybe up to about 200 or 300. And then under them is the military. And this unitary executive theory is considered there's a battle within different legal scholars. There's a weak version of this theory and a strong version. And basically, it's within the Article 2 for the president to have this power, and it's that he possesses the power to control the entire executive branch. And it uses the terms, he is vested with executive power. So there's strong disagreement about the strength and the scope of the doctrine. And there are many who favor a strong unitary, and then there are others who want a weak. So the strong unitary people, which means a strong single person, that's what unitary is, one. So one person, the president, has this power, and there's many people who believe that this is what the president should be, should not be so limited by the Congress to interfere in his decision-making with all these people under him. So even though he has to get Senate approval to have people put into the heads of these departments, the president actually has the power to dismiss any of those heads. And he doesn't have to give any reason. It's just at his whim, which we have seen through many, well, recently, this most recent administration, how this cabinet door is swinging all the time because there's new people coming as old people leave that have been dismissed. And we'll go into more of that tomorrow, later on the second one. So the general principle then is that the president controls the entire executive branch, which would include 114 million federal employees. There's 4,000 alone in the office of the president. And then when you think of the 2 million in the military, they are all under his control, which also means the Justice Department, the police departments, all of those things fall under the heads of these departments. So it's quite powerful. White House counsel John Dean said, in the most extreme form, unitary executive theory can mean that neither Congress nor the federal courts can tell the president what to do or how to do it, particularly regarding national security matters. Now, the root of all of this is based, like I said, in Article 2. And it says, quote, the executive power of the United States shall be vested in a president of the United States. So he has the right. It is conveyed to him. And then it's connected with, the president shall take care that the laws be faithfully executed. So this creates a hierarchical, unified executive department under the direct control of the president. So we do have the pyramid where it all starts and stops with the president. So basically, this strong unitary executive power puts very strong limitations on the power of Congress to remove executive agencies or officers from presidential control. And then he, as the president, he can fire people at will and hire another person, which will then have to go through the Senate confirmation process. Now, this unitary theory does have judicial implications, because if the executive branch, okay, let's say there's a part of the executive branch that cannot sue another part because the executive cannot sue himself. So if the federal courts were to put on trial the disputes between the executive agencies, it would violate the doctrine of separations of power. Now, interestingly, in 1787, when they were at the Constitutional Convention, this topic came up and it was heatedly debated as to whether to have a unitary executive or a plurality, which is more than one executive. It would be like an executive council or several executives. So overall, we see how the framers of the Constitution gave us three branches with powers to check and to keep the others in balance. And this was the original concept and purpose. Then within these, Article 2, it goes into a little bit more detail on the executive powers. So I'd like to give a few examples of how presidents in our history have used the executive power, unitary executive power. There's something called a signing statement. And basically what happens is when a president signs a bill that he receives from Congress, he will basically announce his view of portions of that bill that he agrees with or disagrees with. And so it's when they do make a signing statement, it's a declaration to say, well, I'm not doing this because, or I will agree to do this because. So in 1987, Ronald Reagan issued a signing statement and basically said, because there was a provision in a bill that he received from Congress that required the president to obey the orders of a subordinate. So he wrote towards the end that it would plainly constitute an unconstitutional infringement of the president's authority as head of a unitary executive branch. So basically he's saying, I'm the president and I'm not going to take orders from anybody underneath me. So he put that clearly out there in the open to let Congress know that he wasn't going to do that. So George W. Bush also did a number of unitary signing statements. And one of them had to do with the treatment of the detainees at Guantanamo Bay. And basically he said they were treating the detainees in a manner consistent with the constitutional authority of the president to supervise the unitary executive branch. So many people felt that Bush was overstepping his duty and his willingness to overrule the courts. In his presidency, George Bush actually signed 363 signing statements of when he disagreed with the numerous bills from Congress. Okay. There's a book that I found that has a lot of history on the presidency, and it was written by Arthur Schlesinger, Jr., and it's entitled The Imperial Presidency. And we'll put that on the thread. It's hard to spell. It's hard to speak. But he wrote a really amazing book on presidential power, and he focused on Richard Nixon. And he touched on the basis, he touched on unitary executive theory, and it actually got a new term after his book. It's now called imperial presidency. So even though they have different definitions, the terms are almost used interchangeably. Although, of course, to be called an imperial presidency has a more negative. So I'd like to give a short example from history of how this imperial presidency works. So in 1798, there was the Sedition Act that was enforced by the Adams administration against newspaper writers who supported Thomas Jefferson, his challenger in the 1800 election. So he's going after fake news, pretty much, that he doesn't like. So that Sedition Act allowed no protesting of the government, no immigrants were allowed in, no freedom of the press, and lawmakers were jailed. So the strong step that Adams took was in response to the French foreign threat that also included severe repression of domestic protests. So then a series of laws, and there are 4 of them, and it's called the Alien and Sedition Acts because there are 4 acts within that one title. And it was passed by the Federalist Congress. So there's at that time, the 2 parties were the Federalists and the Democratic Republicans, which Jefferson was a Democratic Republican. So basically, these laws included new powers to deport foreigners, as well as making it harder for new immigrants to vote. Previously to this bill, this act, a new immigrant only had to live in the United States for 5 years before becoming eligible to vote. But the new law raised it to 14 years. So the Federalists saw foreigners as a threat to American society. Now, mind you, this is 1798, okay?
Thank you.
Yeah. As one Federalist in Congress declared, there was no need to invite hordes of wild Irishmen, nor the turbulent and disorderly of all the world to come here with a basic view to distract our tranquility. Well, interestingly enough, the non-English ethnic groups had been the core supporters of guess who? The Democratic Republicans. So Adams was protecting himself and trying to keep himself in office. And so this began back in 1796. And so in 1708, this came out. The most controversial of the new laws permitting strong government control over individual actions was the Sedition Act. In essence, this act prohibited public opposition to the government. Fines and imprisonment could be used against those who write, print, utter, or publish any false, scandalous, and malicious writing against the government. Under the terms of this law, over 20 Republican newspaper editors were arrested and some were imprisoned. The most dramatic victim of the law was a House representative named Matthew Lyon of Vermont. His letter that criticized President Adams, quote, unbounded thirst for ridiculous pomp, foolish adulation, and self-abhorrence, greed, caused him to be imprisoned. So while the Federalists sent Lyon to prison for his opinions, his constituents re-elected him to Congress even from his jail cell. The Sedition Act violated individual protections under the First Amendment of the Constitution. At this point, though, the judicial review that I pointed out up here, the judicial review had not been established at that point. It was not well developed. And furthermore, at this time, so John Adams is the second president. George Washington, the first president, picked the Supreme Court, and every one of those justices were Federalists. So as a result, Madison and Jefferson, who were Democratic Republicans, directed their opposition to the new laws to the state legislatures. So get this, they didn't like the federal law, and so the states were still independent, and the states of Virginia and Kentucky, which were from Jefferson and Madison, they passed resolutions declaring the federal laws were invalid within their states. This was a bold challenge to the federal government, and it offered strong states' rights a position. It actually pointed to imminent armed conflict within the United States, so a possible civil war. So the Federalists really felt like their party, it was up to their party to save the Republic. And the interesting thing, when Jefferson and Madison had their legislatures voted against the Sedition Act, by placing the states' rights above those of the federal government, Kentucky and Virginia had actually established a precedent that would be used to justify the southern states in the Civil War to leave the Union. So it's interesting that 60 years later, the impact of things that have happened. So that was an example of the president using his unitary executive power to silence his enemies, to prevent new immigration being able to vote, because he knew that they were not on his side. There were other presidents. Let me see, I have a few here. Okay. 15. Oh, okay, good. I thought I had shorter. In that case, we'll talk about, okay, in 1803, it was Marbury versus Madison. And this is the first time that the Supreme Court announced the principle that a court may declare an act of Congress void if it is inconsistent with the Constitution. And there's the beginning of judicial review. So this came out, the articles, these three articles were 1789. In 1803 is when judicial review was established, where the Supreme Court would then be able to put a check on the executive branch and the legislative branch. And it was a court case where this man, William Marbury, had been appointed a justice of the peace for the District of Columbia in the final hours of John Adams' administration. But James Madison, who was Thomas Jefferson's Secretary of State, refused to deliver Marbury's commission. So then Marbury took him to court, and the long run of the effect has been to increase the court's power by establishing the rule that it's the province and duty of the judicial department to say what that law is. So basically, it had established an important check on the government branches. Then in 1832, President Andrew Jackson openly defied a Supreme Court ruling. It was against the courts had said that he did not have the right to impose regulations on Native American land. So he refused to enforce the ruling, and that decision helped form the basis for most subsequent Indian law in the United States to protect them more. Then there's Abraham Lincoln. He took on unprecedented wartime powers and violated multiple civil liberties on a large scale during the Civil War, including due process rights for the US citizens. He even ignored a decision of the Supreme Court. His name was Chief Justice Roger B. Taney. And the reason Taney had found that his suspension of habeas corpus rights in 1861 during the Civil War was unconstitutional. And I looked up habeas corpus so that I could explain what that means, because I didn't have a clear understanding myself. But literally in Latin, it says, you have the body. And it's a term that represents an important right to individuals in America. And basically it means that a judicial mandate requiring that, it is a mandate that requires the Justice Department or the judge or whoever's arresting you, that a prisoner must be brought before the court to determine whether the government even has a right to continue detaining you. And that is a basic right we all have in the United States. And the individual being held or their representative can petition the court for such a writ. Now, there were times that the habeas corpus was suspended, and it was during the Civil War and Reconstruction, and it was done in parts of South Carolina during the fight against the Ku Klux Klan, but it was also suspended during the War on Terror with George Bush, yeah. Another example would be President Woodrow Wilson. He suppressed free speech, he deported immigrants based on their political beliefs, and he ordered massive unconstitutional raids. His policies were so draconian that they inspired protesters to form the American Civil Liberties Union in 1920. During World War II, President Franklin D. Roosevelt issued an executive order calling for the forced internment of over 120,000 Japanese Americans, as well as forced surveillance, ID cards, and occasional relocation for immigrants from other perceived hostile nations. And then President Richard Nixon, he used the executive branch law enforcement agencies to attack his political opponents, and in the case of Watergate, to actively cover up his supporters' criminal activities. There was one example by President Clinton claiming that sitting presidents are immune from lawsuits. And the Supreme Court rejected that in 1997. So Congress passed several laws restricting the power of the executive branch after Nixon's imperial presidency. Among these was the Independent Counsel Act, which allows an employee of the Department of Justice, and thereby technically the executive branch. So anyone that's in this hierarchy of the pyramid here, anyone in here is considered part of the executive branch. So they were allowed to operate outside the president's authority when conducting investigations of the president or other executive branch officials. So the Supreme Court found the act to be constitutional in Morrison versus Olson in 1988. Let's see. President Clinton tried to convince Congress to pass a line item veto act in 1996, and the Supreme Court struck that down in 1998. So we can see that the three branches of government is very delicate. as we know that because the president has so much power and he has the military under his command and he has the Justice Department, of which the head of it is William Barr. So basically, when we see currently President Trump ignoring the actions or requests of the Congress, there's been no ability to do anything about it. He just is flagrantly ignoring those requests for subpoenas or answering the subpoenas or sending in witnesses. So we have a lot to admire about the process that was created, but ultimately the system is only as good as the people who are in the system. And that's where I see the failure and the breakdown. So when it came time, just to summarize, when it came time for the framers to establish, the founders to establish a government, they turned to a written constitution, which to us doesn't sound really unusual, but at that time period, it was something radically new. And our nation was the first to do that. And it was a unique attempt to limit government in order to preserve liberty. And even today, many nations will model their constitution after ours. And even now, our understanding of the importance of the Constitution has really decreased over time, in that it's almost like in the schools, it's a boring history class and you have to memorize dates and names of people, and it's not anything that means anything to you. And when you really start thinking about those times and the history that surrounded the forming of this country, to have a government that is created and founded of the people, by the people, and for the people was truly radical. And they put it on paper. They wanted to enshrine it so that all would know what their rights were and what the responsibilities were of the people. And I see these three branches, and I'm seeing more and more that they really are dependent on how they work based on the people. And in the second presentation, we'll go through a history of how these branches have been cracking because of the different people that have been in office as president. So the greatness of America is the Constitution, and it maintains a limited government, providing for life, liberty, and the pursuit of happiness. But over time, our presidency has gone out of control, and obviously many times exceeded its constitutional limits. In the books that I was reading, there was an almost daily accountability of the president to the Congress, to the courts, the press, and the people. But now, the accountability seems like it's only every 4 years. Okay, we're going to vote you out, instead of holding their feet to the fire on a more consistent, regular basis. So I believe we have a government structure here that has fallible people, fallible human beings governing fallible human beings. And I think that the weakness is in both. That there were, they could have done something to I think they had a much higher view of the people that would be in the offices and that this system would work. So I'm going to finish early because I talk too fast. And so we'll take a break and we'll continue in the next section on looking at the history of the imperial presidency. We'll close with prayer. Heavenly Father, we thank you, Lord, for your goodness and mercy. We thank you, Lord, for all this truth that you are showing us. We ask you for your continued presence, for opening our minds and our hearts to continue converting us to the image of Christ. We thank you for all you have done for us and for all that you will do. We praise you and thank you in Jesus' name. Amen.